want us to stand here?
Please, yeah. All right, we're on the record now in People versus Jennifer Palmer. This is file number 255413.
Jesse Williams with Ms. Palmer.
Sierra Coke on behalf of the people.
All right, and I know council's aware of this, but I just want to caution council again. This case does involve a minor victim, so I'm going to ask everyone to refrain from using the victim's name during proceedings here. The victim can be referred to as either victim or by initials. This is the date and time set for a sentencing hearing in this matter. Ms. Palmer, you had a chance to go through the pre-sentence report and talk to Mr. Williams about that.
Yeah.
And Mr. Williams, are there any additions, deletions, or corrections to the body of that report or the actual?
Did the court receive the risk assessment formed by Burgess' office? That was filed as an attachment. It should have been attached. So there's a risk assessment, and Your Honor, just to be frank on the way here, I remember that this court requires or requests the attorneys to file a memorandum on challenging OVs, BRVs. I'm sorry, I forgot. I mean, I'm just in different circuits and everything. Different. So I do have OV challenges for 10, 13, and 19. I think it's important. She actually went and had a risk assessment done by the Burgess office, which works exclusively with the youth sex offender program in Kent County, exclusively with that court. And it was important for the court to have that information. I don't know if there's time for the court. I don't know if you want to adjourn it, you want to review it. I don't know what you want me to do. I'm just asking.
I'm not going to adjourn because we're all here. We've got victims that have been present, so I'm not going to adjourn it. I don't know.
I just texted Jeff.
I'll make argument regardless. I'll make sure the court has that document shortly.
Okay.
But it's important. It's critical. If we did not send it, that would be a mistake by my office.
Yeah, I don't know. All I know is given everything else.
You are, and I agree with that. So I don't know. That being said, where do you want me to start, Your Honor?
I guess first, I want to make sure that there aren't any additions, deletions, or corrections to the body of the report.
No, we're only making factual challenges to that, and correct. We're not asking the court to delete it. We'll just make argument on anything that's in the report.
All right. So your first challenge is, you said, the OB10.
The OB10, and it's scored for exploitation, and I understand that as charged, because she works in a penal institution, that statutorily that's a logical argument. But as far as scoring, the statement from the victim is very clear that the victim engaged Ms. Palmer, sought out Ms. Palmer, and proactively wanted this to occur in the victim's life. So in scoring, I'm assuming the 10 points is for the youth or agedness, and the argument is that but for the penal institution at the time this incident occurred, at least for the facts of this plea and the PSI, the victim was of consenting age. The victim would have been 16 at the time, as far as the factual basis of the plea is concerned. So, but for the penal institution, this wouldn't have been a crime. So the argument that the youth or agedness of the victim was exploited, it's not defined in the instructions. So I'm arguing that it shouldn't be scored in this unique instance.
And I actually considered making the argument that under OV 10, she should have been scored at 15 for predatory conduct. I read through the investigation that was conducted initially at Shawano, where the young victim indicated that there was no sexual assault. We have since had a baby that the DNA has proven to be, as of Friday, the youth child. I went back from the date of conception and it was
Just wanna
8 days.
Okay.
What I just object is the DNA is not part of the PSI. It's,
Well, I mean, there's no question that the child that was born to this is the victim's child, correct?
I'm not arguing DNA, I'm just saying it was never part of the record or for the purpose of this,
There's reference to it in the PSI. Sentencing hearings are not subject to the rules of evidence.
fair enough, I just make the objection, Your Honor, just.
Yeah,
for the
okay,
record.
that's preserved for the record, but.
Thank you.
That's cool.
When I did a backwards calculation from the date of the birth of that child to the youth's 16th birthday, it was the date of conception was 8 days after that juvenile turned 16. 8 days is when the conception of that baby is, if it's a 40-week period. I say that because I think this definitely should be scored for exploitation. We are talking about a 32-year-old woman who was a police officer, and then she was a Shawana worker. She had control over everything with this youth, when he was allowed out of his cell, when he was allowed to use the phone, what privileges he had. She had complete authority over him. And I understand that he thinks he is not a victim because he was, 8 days after turning 16. But she certainly had every bit of age on him. I think the difference in age, the exploitation of her position clearly shows that it should be scored at least 10 points. Thank you.
All right, so the variables, the court has to score variables. The court has to determine that there are facts by preponderance of the evidence, in other words, more likely than not, or just tipping the scales one way or the other to support actually the scoring of any particular variable. The court can use information contained within pre-sentence reports, victim impact statements, police reports, sworn testimony such as that given at preliminary exams or other proceedings in making those factual determinations. In this case, the challenge is to OB10, which is exploitation of a vulnerable victim. It's scored at 10 points, indicating that the offender exploited the victim's physical disability, mental disability, youth or agedness, a domestic relationship, or that the offender abused his or her authority status. Looking at the case law behind OB10, it's not the mere presence of one or more of those factors, it's the exploitation or the use or the taking advantage of one of those factors by the defendant that allows for scoring of OB10. So in this case, I know it's not just that the victim was 16. It doesn't matter whether the victim was of the age of consent or not of the age of consent.
Well, that took a turn. This sentencing hearing for People v. Jennifer Palmer was intense and complex from the start, with Judge George Mertz presiding over what is undoubtedly one of the more emotionally and legally charged cases to come through the courtroom. The charge involved a former corrections officer accused of engaging in a sexual relationship with a minor under her care, someone who was incarcerated at the time of the alleged incidents. The court opened by firmly reminding everyone not to mention the victim's name due to their minor status. Setting a respectful tone. Ms. Palmer had reviewed the pre-sentence investigation report with her attorney, Mr. Williams, who came to court prepared to challenge several sentencing variables, specifically OV10, OV13, and OV19. OV10, for those not familiar, deals with exploitation of a vulnerable victim. The crux of the argument was that while the statutory crime hinges on the setting, a penal institution, the victim in question was technically of age 16 years old at the time of conception. The defense claimed the minor initiated the relationship and argued that without the prison setting, there wouldn't have been a crime. Essentially, no exploitation, just bad judgment, but the prosecution, led by Ms. Koch, wasn't having it. She countered with the stark reality. Ms. Palmer was 32 years old and in a position of institutional power. She had control over the youths, access to the phone, his movement, and even his privileges. Ms. Koch emphasized the imbalance of power and how Palmer's role gave her outsized control, making this a textbook case of abuse of authority. She even went further back, calculating from the birth of a child to show that conception happened just 8 days after the victim's 16th birthday, Reinforcing the troubling timeline, Judge Mertz, as always, stayed cool under pressure. He calmly explained how scoring works. The court must find facts, by a preponderance of the evidence, essentially more likely than not. He also laid out what sources the court can consider: police reports, victim statements, sworn testimony, and the pre-sentence report. Mertz emphasized that it's not just about whether the victim was underage, but whether the defendant exploited their status or authority. Based on the arguments, you could sense that he was leaning toward affirming the 10-point score for OV10. The entire proceeding was steeped in legal nuance. There was no shouting, but there was a heavy emotional weight in the room. The defense wasn't disorganized, but they were on the back foot. Mr. Williams admitted to forgetting the local requirement to challenge OBVs by written memo. Still, he tried to steer the conversation back to fairness and factual specificity. The prosecution, by contrast, was precise and relentless, the vibe in the courtroom, tense but contained. Judge Mertz kept things from veering into spectacle, but the stakes were unmistakably high. With a victim present, arguments about consent and culpability felt razor-sharp. And through it all, the court maintained a balance between legal rigor and human sensitivity. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.